I can see the slide. Thank you, Ishana, for the introduction. And thank you everyone for attending this session. It is really exciting to be part of this model law work project. So I'm a Japanese lawyer. I'd like to share my knowledge about my jurisdiction, Japan. Okay. My jurisdiction, Japan, has adopted the model law on cross-border insolvency, but has not adopted the other two model laws. So today, firstly, I'm going to explain about the Japanese law enacted based on the model law on cross-border insolvency, and after that, briefly touch on the current status of the discussion towards the adoption of the other two model laws in Japan. Okay. Firstly, Japan is actually an early adopter of the model law on cross-border insolvency. So Japan enacted the Act on Recognition of an Assistance for Foreign Insolvency Proceedings. I call it Recognition Act in this presentation, based on the model law in 2001, which is 4 years after UNCITRAL adopted the model law. But in fact, the number of cases where the Japanese court recognized foreign insolvency proceedings is quite small. There are only 17 cases, 17 cases during the 23 years since the Recognition Act was enacted. There may be multiple reasons for that, but from a practitioner's point of view, predictability might be one of the reasons. So as there are not many precedents, the recognition proceeding in Japan is less predictable. But on the other hand, it is not very difficult for a foreign company that has assets in Japan to file for domestic insolvency proceedings to the Japanese court. So the practitioners tend to use the latter domestic insolvency proceedings. So, and I'd like to point out some differences between the Japanese law and the model law in this presentation. So the most significant difference is that there's no automatic effect resulting from the recognition of a foreign insolvency proceeding. So under Article 20 of the model law, the recognition of a foreign main proceeding has a certain automatic effect. For example, legal actions against the debtor's assets are automatically stayed. On the other hand, under the Recognition Act, under the Japanese law, the recognition order itself does not have any substantive effect. So if you like to suspend the legal actions against the debtor or prohibit the debtor from disposing of its assets, you need to file a petition for separate relief orders. Also, another important difference between the Japanese law and the model law is the cooperation and communication between the court and a foreign court or foreign representative. So under Article 25 of the model law, the court shall cooperate to maximum extent possible with foreign courts or foreign representatives, and the court is entitled to communicate with such foreign bodies. However, Japan has not introduced equivalent provisions. Legislators explain that communication between the Japanese insolvency representative and a foreign body would be smoother and more effective than communication by the court. But I understand that over the past 20 years, the court-to-court communication has been getting more active and important in the context of cross-border insolvency. So We should probably discuss again whether the cooperation by the Japanese court should be stipulated in the Japanese law. Okay, there are some other differences, but due to the time constraint, I'm not going to explain the details. Okay, next, I'm going to introduce some actual cases. Although we have only 17 cases during the last 23 years, there are a few cases to be noted from practical perspectives. The first one is Azabu Tatemono case. The issue in the case was whether or not debt relief based on foreign proceedings is effective in Japan. So in the case, the debtor filed a Chapter 11 petition because it operated a hotel business in Hawaii and also obtained recognition of Chapter 11 as a foreign main proceeding under the Japanese law. And the plan of reorganization, including the acquisition of the debtor's business by an investor, was established and approved in the Chapter 11 proceedings. But there's no clear provision or precedent regarding whether or not debt relief based on Chapter 11 or foreign proceedings is effective in Japan. So it is highly unlikely, but still theoretically possible that the effect of the debt relief under Chapter 11 could later be challenged in Japan. So the debtor filed another petition for formal insolvency proceedings, which is corporate reorganization proceedings in Japan. So, okay, in the second case is a Think 3 case. The issue in the case was the criteria for recognition as a foreign main proceeding. So in the case, the debtor had its registered office in the US, but had a sales office in Italy. At first, bankruptcy proceedings commenced in Italy, and the trustee was appointed. And after that, the debtor initiated Chapter 11 in the US and also filed a petition for recognition of the Chapter 11 under the Recognition Act in Japan. And the court granted the recognition. Thereafter, the trustee in Italian bankruptcy proceedings also filed a petition for recognition to the Japanese court. So there was a dispute as to which was the foreign main proceeding, Chapter 11 or the Italian bankruptcy proceedings. So under the Japanese law, a foreign main proceeding is defined as foreign insolvency proceedings petitioned for in the country where the debtor's principal place of business is located. So in the the court clarified in its decision that the term, the principal place of business, is basically the same as komi under the model law, and should be determined on a case-by-case basis, taking into account various factors. And finally, the court decided that the principal place of business was located in the US, and the foreign main proceeding was Chapter 11. Okay. Lastly, I'm going to briefly touch on the other two model laws. So, as I mentioned, Japan has not adopted these relatively new model laws. But is there any movement towards the adoption of the model laws? Actually, there isn't. Some professors introduced a summary of these two model laws in Japan, but it appears currently practitioners are not interested in them, and there's little discussion about these two model laws in Japan. So that is probably partly because, as I mentioned earlier, Japan does not have many cross-border cases to date. So the priority to adopt these model laws is not very high. But yeah, but recently the number of insolvency cases in Japan has been increasing. So the situation could change.
Thank you so much, Kotaro.